It is finished, at least this part of the journey. The historic election petition case concluded first with closing words from Dr. Henry Stagumba Brown, who represented the Honorable Hensley Daniel, Deputy Premier of Nevis, named as the first respondent in this case. In his 75-minute discourse, Dr. Brown told the court that it had no jurisdiction to hear certain matters in the election petition case. He referred to the issue of equal access to the state media. He stated that this would limit his lordship in the relief that it can grant to the petitioner. Lead counsel for the petitioner, Douglas Mendes, SC, in his final rebuttal to the court, refuted the claims by Dr. Brown that the court could not hear such matters. In the area of objection notice, specific to the registration officer's responsibility to ensure that objection notices are sent out and received, Senior Counsel Mendes brought in additional authorities on the matter, which suggests that Parliament's intent when drafting the legislation was to ensure that persons indeed receive the notice of objection. The respondent side have exhibited and admitted that this is what their case is hinged on. At the end of the submission by Senior Counsel Mendes, Justice Jones asked what relief they will be looking for. The request is that the election be declared invalid and that the register of voters remains as it were at January 31st, 2011. He also asked what would be the next procedure if the elections were to be declared invalid. It is understood that the next step would be to send a certificate from the court to the clerk of the Nevis Island Assembly to declare a by-election. In closing up the 2-week court proceedings, His Lordship Justice Jones thanked all legal counsel in assisting him on the matter and stated that final written submissions are expected no later than February 10th. Thereafter, a judgment will be decided at a date to be announced. After the court proceedings, the View and Newsline caught up with the Honorable Hensley Daniel. We asked him for a response on this historic election petition case, but he stated to us that he would not be providing any comments. However, petitioner, the Honorable Mark Brantley, was greeted by loud crowds of supporters on the step of the courthouse, provided us with this view.
We're very happy with the way things went. We thought the evidence that was led was very convincing. The law, we feel, is very convincing, and it's now in the capable hands of the judge, and we await the decision whenever that comes.
That's the Honorable Mark Brantley. We also got these contrasting views from individuals on the outside.
I thought that both sides presented their side well. In my mind, I liked the way the petition brought forward the case because they in themselves were appealing to conscience, appealing to the inner man, whether it is right or wrong for some of the actions to be taken. And so I understood the way he presented his case. But then you had the respondents going on a point of law. What is constitutional right? I may not like the way certain things are, but if it is in accordance to the law itself, then I can put my personal feelings in it. And I thought that Dr. Brown and Askafan Senior Counsel did an excellent job of presenting the law in itself. I am really thinking that the respondent side did a better job in presenting their part of the case, and I think that the respondents will prevail.
I was very offended being a disenfranchised voter when the lawyer for the first respondent referred to the disenfranchisement of voters as a spacious technicality. Your fundamental rights cannot be a spacious technicality. It is a fundamental right. And I think the lawyer, the senior counsel for the petitioner was right when he called it tabulated legalese. It was like, as I said to somebody yesterday, the presentation for the senior counsel yesterday was like going fishing and coming back with mangoes. You know, it was totally irrelevant to the case.